We have breaking news now. Lawyers for Donald Trump are moving for a mistrial because of what was said during the testimony from adult film star Stormy Daniels. Of course, you must remember Stormy Daniels is at the center of this trial. Trump is being accused of falsifying business records to hide a payout that his former lawyer, Michael Cohen, made to Daniel, a total of $130,000 in the final weeks of the 2016 presidential election. Her testimony, of course, included some of the details of this alleged sexual encounter between the former president 10 years before the election. The alleged incident dates back to 2006. But the payments were made in 2016. There has been a great deal of attention in this case, not just because it is the first time that a former president is facing a criminal trial, sitting there in court almost every day of the week. Now, this being his third week to have to attend trial, while he's also campaigning to hold the presidency later in November in the election. Stormy Daniels is a crucial witness to this case because her testimony, in a way, not only validates the allegations of the affair, or not the affair, the sexual encounter, rather, which former President Trump has consistently denied, but also of all of the workings that the people around Trump and people like Michael Cohen, fixers, lawyers, et cetera, allegedly went into to improve his image ahead of the 2016 election, including what some of the other witnesses who have testified in this trial have talked about, which has to do with a scheme to catch and kill stories, namely the director of the National Enquirer talking about how stories were identified that would be detrimental to Trump's reputation and therefore detrimental to his possibilities of winning the election. And once the magazine would buy or pay or catch these stories, then they would not be published and people would be prevented from going to other media outlets to talk about these stories. We have, of course, team coverage in Lower Manhattan and across our legal contributors who will continue to join us throughout the hour. But just to recap a little bit, the Trump defense team today has filed a motion to ask for a mistrial. Joining us today to break this all down is CBS News legal contributor Jessica Levinson. She's been standing by to provide some analysis. Jessica, thank you so much for joining us. She's also a professor at Loyola Law School. So Jessica, this trial is unlike any other for way too many reasons to list right now, one of which being the judge has found Trump liable for breaking a gag order 10 times. He's have had to pay $10,000 so far. Now this also has to do with what is being said during testimony and how that could impact the jury's decisions. Talk to us about what are the grounds, what is it that they're calling for, and how much of a case would they have to declare a mistrial given what Stormy Daniels testified on?
Well, it looks like the judge said not enough of one. What the judge said is that there was too much detail in her testimony and that she basically went outside the bounds of what she was supposed to say.
Jessica,
Trump's team has said...
I want to interrupt you very quickly because now we have learned that the mistrial was denied. So I want to make sure that we're not speaking in hypotheticals, but in the facts. They asked for the mistrial. It's been denied. But I'll give it back to you. What is it that they would be seeking? And now that this is denied, you're not inside that courtroom, but what can you assume is in the judge's mind?
So based on the reporting I saw a few moments before we went live, the judge denied this based on the idea that he could still instruct the jury to disregard any testimony that was problematic, that went outside the bounds of what is relevant. And I think you were absolutely right to say in the beginning that this is a trial that is unprecedented. But there are pieces of this trial that we have seen before, that the American criminal justice system is able to respond to. We have had gag orders in the past. We have also had, and this is not completely infrequent, but defense counsel say, we need a mistrial. This witness said more than they should have, and the jury is tainted, and we can't possibly go forward. And that is very consistent with not just any defensive strategy, but particularly this defensive strategy to try and stop the trial, get it to be delayed, and then maybe even try and change venue and get a different judge. This afternoon, we know the judge really wasn't having any of it, saying, I'm still in control of the courtroom, even though Stormy Daniels might have said more than was agreed upon, or we have to look at the details of exactly what she said and what went kind of outside the bounds of what is allowed. But this is something judges say all the time, which is, I can instruct the jury to disregard something they heard. And even though the jury will never forget it, they're not supposed to consider it when they go back to determine their verdict.
And that is something that happens in trials. I mean, plenty of trials that I've covered, they say you basically ignore what you just heard from that witness. But of course, timing here, Jessica, is of essence. I mean, what the Trump team is trying to do is continue to delay not just this, but other trials still beyond the election for multiple reasons. Do you think that, though, this filing this motion could have an impact in any way or provide any kind of grounds for the Trump team to appeal later, given that they're asking for the mistrial now? Does that affect it?
So this is going to be, if Trump is in fact convicted, then this will be part of, or if there's a hung jury and the prosecutors decide to try and retry, depending on kind of when procedurally an appeal would happen, I think there are grounds for an appeal. And Lilia, you and I have talked about some of them. This is a complicated case, and there are a bunch of legal hurdles that the prosecution has to overcome. And now we have, in my mind, one more chapter in that appellate motion. So now we have a chapter on the fact that they think this testimony was problematic, it tainted the jury, and that it amounted to the need for a mistrial. Now, of course, it's always kind of easier to prove that in the moment than after there's a verdict, when an appellate court would be less likely to overturn that verdict. But there are other chapters in that appellate brief, that we've talked about in the past, and we could still talk about now, which is just to say, there are still a lot of hurdles for the prosecution in this case. It's not just new because it's the former president of the United States. It's also a situation where we're using a misdemeanor law, falsification of business records, and we're trying to kick it up to a felony based on saying that there was another crime committed. Maybe that crime was federal, maybe that crime was state, but it's not the typical way you see a case like this unfold.
And considering that, with that in consideration, Jessica, you are the expert. You are that mind that I reach out to for legal advice across the board. I'm curious, of all of the things that Stormy Daniels has to testify on, of course, I'm sure that a lot of people would want to hear about the actual encounter or the alleged encounter or what happened in those details. What's the most relevant part of her testimony? What's the key part that the prosecution is trying to get from her? What can she prove for them?
I think the key here, and you shouldn't need an expert for this in the sense, not you, but anyone, if the prosecution does their case correctly, it should be apparent to the jury as well. And I think what they're really trying to get at is, do you think you would have gotten this payment if there were no election? Because you actually tried to get paid before. It didn't work. So in fact, isn't it probably the case that this payment was made so that you did not share your story with the voters? It wasn't to keep you quiet so that the family didn't hear your allegations, or that those who do business with Trump didn't hear your allegations. It was to make sure that the voters didn't hear. Now, that is still different from proving Trump's intent, but everyone around who dealt with him, that is how you prove his intent. That is how you say to a jury, he wanted to conceal or commit another crime, and that other crime was either federal or state election fraud. I'm
curious if that's the case. I mean, if the most important part about this is positioning the electorate, I mean, that voters are the core, not Melania 10 years before, not his reputation in general, but because of the election. But the election interference part is not what he's being charged with here. How does that complicate things?
So, and I should be clear, I think there are other reasons that Stormy Daniels is here, and she will definitely talk about her dealings with, how she received these payments. There's a payment that is at the center of this case, And she is the recipient of that payment. And she's going to talk about the details of that. She's going to talk about the negotiations, or she did, I should say, and talk about, again, the purpose behind the payment. You're absolutely right that he is not being charged with federal campaign finance violations or state election interference. And this actually, Lily, comes back to something we were talking about just a few moments ago, which is the prosecution's case doesn't depend on proving that, on getting a conviction for those other crimes. What it depends on is proving that those business records, the payment to her, that created this falsification of business records because Trump was trying to commit either federal or state election law violations or tax violations. And so I know this sounds complicated, but the prosecution doesn't need to get a conviction for those other crimes. The prosecution does need to show that he allegedly lied on the business ledger in order to commit or conceal those other crimes.
Jessica, as always, thank you so much for making things so clear for us.